Okay, good afternoon, everyone. Because we didn't start on time yesterday, we're starting 2 on the dot today. Good afternoon, learned senior advocates, judges, senior colleagues, and colleagues on the call. I'm going to start today with an apology. Mr. Babatunde Bamigboye, the head of legal for the Nigeria Data Protection Commission, was supposed to start this session. Unfortunately, his flight from Abuja to Lagos was delayed, so he won't be able to take part in this session. And the next session is for Justice Ibironke Harrison. So I'm going to stand in, and this is going to be as interactive as possible so that we can all learn 1 or 2 things on audits. I'm just going to speak for 20, 25 minutes, then we can have questions before Justice Harrison comes in. Whatever I say, they are my thoughts. They are my understanding of the subject. They are not Mr. Babatunde Bamigboye's understanding. He is in the civil service. I am in private practice. So definitely perspectives might be slightly different, especially from the angle of being a regulator and that of being a practitioner. So very quickly, we're going to be looking at what the very quick things we need to know about audits. When I say audit, I mean data protection compliance audit. You can call it privacy audit. You can call it compliance audit. You can call it whatever it is, but it has to do with audits around the use or processing of data. So what are these very quick things we need to know about audit? Most times we make this error when we conduct audits for a client. The client might even say we're compliant. I haven't gone through the audit. The client just assumes they are compliant. I think we need to correct that misconception. Audit in itself does not represent compliance. Because audit does not absolve you of liabilities for data protection, compliance, or your obligations under data protection legislation. Then audits, they don't always have to be favorable. And that's a problem that lawyers will most likely have. You conduct audit for a client, and the client expects everything to be fantastic, or they expect to have a clean slate. Well, it is our own professional duty to explain to them what audits are and why it should not always be favorable, even if the client wants it to be, except you now do certain remediation that makes it a little bit more favorable to the client, but audit would not ordinarily always look good to the client. Then audits generally don't have to be once a year, because the whole idea of audit is to check. The next slide will speak to that. Then you see that these are activities that need to be done as often as possible when you check the objectives of an audit. Then what exactly are audits? So the Nigeria Data Protection Regulation Implementation Framework that was issued in 2020 defines it as a systematic investigation or examination of records or processes or procedures of the controller or the data processor to ensure that they are in compliance with the requirement of the relevant laws. So audit itself is not compliance, but audit is to ensure compliance. And we need to mark the difference so that when you conduct audit, the whole essence of audit is to ensure compliance. So the process of audit, so many things will be exposed. So many things will come to light. So many things will need to be put aright. And that's the way the implementation framework has defined audit. Now, the same NDPR speaks to audit in the sense of frequency. It says you should conduct it annually, but that one refers to filing, when you have to file. Filing audit is annual, but conducting an audit, from my experience and the advice I would give, should not be once in a year, because once you do it, sometimes some clients do it and they just go to bed. Certain things need to be done to check whether those gaps found have been plugged, whether improvements have been made afterwards. So in terms of regulatory audit, it is annual. Sometimes March, sometimes they are extended beyond March. Now, under the new act, surprisingly, yesterday when we were speaking to the new act, we mentioned a number of provisions that need to be tweaked, provisions that need to be maybe not necessarily amended, but maybe supplemented, maybe explained by the regulators. If you look at the act, the way you will find audit under the NDPR, you will find it like that under the act. The act simply provides for licensing, and I have a problem with the word license. The act empowers the NDPC to license organizations to perform audits. I have a slight problem with license, because lawyers have license. We have statutory license. So you can't be licensing us again to be able to conduct audit. I would rather prefer maybe accreditation or registration, just like what CAC does, accredits lawyers to. CAC is not licensing lawyers, rather giving us accreditation to be able to do certain things with the commission. So that's the same way I think the act should approach it, in terms of what we can do with whatever permission they give us to do. So the act gives bodies license to audit and give compliance report. There's so many areas. There's so many areas that require tweaking under the act. That also the act contemplates that controllers and processors will file compliance returns, and this is found in section 6D. Whatever compliance returns mean, whatever form they are going to take, we are all still in the dark, but we're still following the regime of the NDPR in terms of what we normally file annually for clients. Now, this is a controversial one. Who can audit? This is a room filled with lawyers, so and I'm very mindful of that. And at the risk of vilification, I would say all lawyers can audit. I just want to leave it like that. If you think you can audit as a lawyer, then you can audit. But when we look at the provision of the act, it is the NDPC is empowered to license organizations or persons to conduct audit. So even though all lawyers can conduct audits, but not all lawyers can file audits. Same way, all lawyers can advise companies or clients on the Companies and Allied Matters Act, but not all lawyers can do certain services or certain activities under CAMA. For example, you want to file anything with the Corporate Affairs Commission, you have to be accredited by them. You want to file some insolvency matters, CAMA subjects that to the supervision of BRIPAN. They are the only ones who can give licenses or give, I don't know what they call it now, some authorization to be able to do certain insolvency and recovery matters. So even though we are lawyers, areas of specialty or specialization, they are regulated by certain sectoral laws or regulations. Now, the NDPC can also audit. Under the implementation framework, they can conduct what they call scheduled audits. For example, a company might be a subject of petition, and the NDPC thinks, oh, they should go and conduct scheduled audits in. Sorry, can you hear me? Somebody said we can't hear you.
We can hear you, sir.
Thank you very much. I just saw a chat when someone says we can hear you. I hope every other person can hear me. So that is for the people that can conduct audits. Now, let me move to the next slide. But I just want to be sure other people can hear me, apart from the people apart from the panelists, because please, if you can just put it in the chat room or in the Q&A that you can hear me. Oh, yes, you can hear me. Thank you. Thank you very much. Thank you very much. That's fine. That's fine. Okay. Now, now I go to the next one. So how do we audit? And I think this is what should interest all of us, because audit is an exercise. Trust me, as much as we are all lawyers, as much as we are all professionals, maybe there are some specialized services that we need to rely on other people to be able to provide, or we need to specifically go and learn it for us to be able to provide. Data protection, I got involved in data protection in 2019, but ever since I have been studying, I've been reading, I've been going for seminars, been going for workshops, been going for litigation surgeries, and also I'm in school, I'm back to school, studying privacy and data protection. So it's something we might still also need to learn how to do some of these things, especially if they are not things that we've been doing over time. So how do you audit? I would say you start with a questionnaire. In the NDPR implementation framework, there's a questionnaire that the regulators have provided for us to use to conduct this audit. They have many questions which speak to compliance, which speak to the current status of the client, which speak to what the client ought to do, which speak to the expectation of the regulators from the client. So in the questionnaire, you answer questions relating to the data breach management procedure. And sometimes it is the data breach, it is when we have a data breach that the searchlight is beamed at certain organizations. I have had to take Ebano Supermarket to court. I wouldn't have taken them to court if they did not have something that looked like a data breach, because the matter is in court, so I can't say so much about it. But it was what looked like a data incident or data breach that exposed myself as a customer to think about, oh, what are they doing? Have we suffered a data breach? Or can we even begin to look at their privacy practices? And that was when we started looking at Ebano's privacy practices. For example, they have CCTVs, they have a database of customers. What are their privacy practices? I mean, I had to look. I looked at them to see what their privacy practice would be at a glance, to know, are there questions we need to ask this organization, especially the fact that they process our data. Now, so data breach would expose so many organizations to these questions. We've seen in the past some banks, we've seen in the past some fintech companies having data breach. Even Lagos State government in 2019, 2020 suffered data breach. So, I mean, these are the things that you want to look at when you are auditing, or these are the things that the regulators are interested in. The regulator is interested in how do they manage data breach? Do they have a procedure? Do they have data breach register? Do they have notification mechanism? Do they even have a system in place, either to check data breach, to address data breach, to remedy data breach, or to notify data breach? So there's so many things around data breach that you would want to audit, whether they even contemplate it at all. Would you remedy it in the event of data breach? Or what would they even understand as data breach? Because what some companies or some entities understand as data breach is not the same with some other entities. So that's another question you ask. Then generally, what their data protection policies? What are they like? What documentation do they keep? You would always want to start from the privacy notices or privacy policies. You start from their websites or their digital platforms. You look at their privacy policies. And I would always say this. Before you can audit, you yourself must have a level of understanding of data protection, because you wouldn't even know what is right and what is wrong. I'll give you a personal experience. A multinational wanted to brief us in 2019 or 2020. They had already been audited by a very big firm. I wouldn't say whether it's a law firm or an accounting firm, but a big firm. They had already been audited, but maybe someone they engaged an internal DPO. I mean, they recruited somebody to be their internal DPO, and the guy had gone for certain trainings. So the man felt, I'm not sure we are very compliant in terms of what we should be doing. So they engaged us to, quote, audit the auditor. And of course, the first question I asked was, before we begin to look at outsiders, can we even look at insiders? Internally, can we see what your policies are? And the first question I asked was, can I even see your letter of employment? So we saw their letter of employment, and coincidentally, the people who audited them had told them that their letter of employment, their engagement process was top-notch, was compliant. I looked at their letter of employment. I didn't see anything that references data protection. I said, okay, fine. Can I see your employees handbook? I checked it. There's nothing about data protection. Okay. And you have been audited that your recruitment processes, your activities around employees or your employment status is compliant with respect to data protection. And eventually I had to ask, okay, so if your letter of employment does not say anything about data protection, your employees handbook do not say anything, do you have a separate data protection policies for employees, maybe just internal privacy policies for employees? They did not have. And I couldn't help it but say, you know what, with what I have seen, I'm not sure you are compliant. I mean, if your employment letters or contract does not say anything about data protection, you don't have internal policies on data protection, then where do we tie the compliance to? So in terms of when you are auditing, you want to look at their policies. What documentation do they have? And the easiest or the commonest one that people will keep will be the privacy policies, internal privacy policies, external privacy notices on the website, on the digital platforms. And for organizations that use CCTV, there should be CCTV notices, because CCTV notices in their premises. These are some of the things you look at. And that's where your work in terms of auditing, that's where you start from. Because you want to see what the policies are. And even if you are filling the questionnaire sometimes is yes or no, which is not also sometimes helpful. The questionnaire will just say, do you have, don't you have? But you might go ahead to want to establish that you have, or you want to explain why you do not have. Then data protection impact assessment. This is also quite important for certain businesses. For the financial industry, it is quite important. For the fintechs as well, important. For health organizations, it is important. Because what it does is it helps you to audit specific processes, specific products, specific events with respect to data protection impact assessment. The law does not generally suggest a product that you should conduct DPIA for, but for every organization that is maybe developing a new product or even their existing product that involves the massive use of data or massive processing of data, A client at a point wanted to stop using manual register for visitors. They wanted to start using automated data capture for visitors. And they never did data protection impact assessment. That thing is very critical because it helps you, it tells you the risks in such processing, the privacy risks, and you are able to advise the client on the less intrusive means of even getting the kind of data they want to get. And in some cases, you might even advise, you know what, the risks are higher. They are higher. You are taking somebody's biometrics, you are taking somebody's face. And these are sensitive data. And it requires certain other safeguards rather than just the regular kinds of. So it puts you under an additional obligation with respect to data protection. So you want to conduct the assessment, you want to make conclusions, you want to give advice on what should be done, what ought not to be done, advice with respect to retention, advice with respect to security, advice on sharing, advice on persons taking responsibility. Staff training. This is also something that is very critical for lawyers to also know, because you want to train your client staff on data protection. You need to know what you want to train them on. And the training will be tailored around their activities or around their businesses. So you want to know what part of their business is vulnerable, what part is likely to expose them to risks. You want to train them on the principles. You want to train them on employees and customers' rights. You want to train them on how to access these rights, how to honor these rights. A couple of weeks ago, a client came to us, wanted to have access to certain data in the custody of a business. I'm just trying to think of how not to let the cat. So I mean, he wanted it to also be able to access certain rights or certain benefits. We wrote them emails, they did not respond. We wrote them physical letters, they did not respond. And those are violations. Whether they have procedure is another thing. But knowing how to respond, knowing when to respond, knowing when not to keep quiet, knowing when not to call the bluff of customers with respect to their personal data is critical, because these are areas that can attract liability under the act. And something that cuts across certain businesses is their inability to have procedure, or their omission for procedure on data accuracy. We've seen cases where banks have been sued for sending emails notification to a wrong person. Maybe at the point of opening of account, the person gave them a certain email and the person did not rectify, or the person did not update those emails. That can attract liability, because if you send email to a wrong party, it is part of your client's obligation to ensure that the data that they keep is accurate. So they must devise a means or a procedure for accuracy, whether 6 months, whether 3 months, but there has to be a means for accuracy, so that they don't attract liability. Even if the person doesn't come back to rectify, you also have an obligation. You have an obligation to ensure that data that you keep is accurate. And I always give an example, a personal example that the experience that I had with accuracy of data. Accuracy of data, somebody spoke about it yesterday, is not just about keeping the data accurate. You must also delete irrelevant data. So there's certain data you keep about, and this happens to employees. There's certain data you keep about employees that it will come back to affect them. I'll give you a striking example. and this affects the legal profession. Just a couple of days ago, maybe yesterday or 2 days ago, the court in the United Kingdom gave a decision on the PIID case. It's all over the place. Fantastic decision. But there's a critical aspect of it that relates to data protection. When the court of first instance or the other court gave its decision, a senior advocate was indicted. It was a terrible indictment on his personality, on his integrity, on his reputation. Now, another court, and that is why rectification is very critical. Rectification is very critical. Accuracy is critical. Updating is critical. The court has vindicated from the report has been saying around, the report has vindicated the Learned Silk. But if you Google, if you check, you will still find reports of the old indictment online. You will still find it in some people's reports. You will find it in some blogs report. And even still yesterday, I still read the report of the old indictment. Now, for as long as this indictment is online, for as long as it continues to be reproduced, it continues to affect the integrity and reputation of this Learned Silk. And it might affect his chances of securing certain briefs. It might affect his chances of getting certain endorsements. It might affect his chances of getting nominated for certain awards or positions. So that is why it is critical for organizations to check, to be up to date in their reporting, to be up to date in their processing, so that if you keep certain data that is no longer relevant, then you need to delete it so that it doesn't continue to affect somebody's. These things are very, very critical to human rights. They are critical to reputation. They are critical to people's lives, livelihood. And that's how critical data protection and privacy is. In one of the court decisions that I will be touching on Friday, on Thursday, my session, this is not my session actually, I'm standing in for Mr. Bamigboye. For people who came in late, Mr. Bamigboye should be airborne right now. His flight was delayed. And he was meant to be in Lagos before 2, but that's why I'm standing in. Now, in one of the decisions, Justice Agim, who is now at the Supreme Court, said privacy is the most valuable right. And a lot of people will argue it. No, it is not. It is just the amount of value we place on privacy. That is why we make such an argument. Yesterday or 2 days ago, I read the story of a man who killed himself because his intimate pictures were, his intimate fact, embarrassing fact about him were posted on a WhatsApp chat room. It tells you how much that thing is intrinsically linked to our lives. We don't understand how it is until one loses or a very critical part of us, or a very embarrassing fact, private facts. Now, I'm not talking about lies. I'm talking about the fact. I'm talking about information about us until it gets public, before you really know how important it is for you to be able to keep your privacy. And that's why, now this also speaks to the information that companies keep, especially companies that keep sensitive information. There are so many HIV patients moving around freely in the society, and they are not victimized, they are not polarized, they are fine. That thing becomes a very important factor if organizations that keep such information don't keep them with care, if they are reckless with it, if it gets to the hands of people it should not get to. And I'm happy this is a convergence of lawyers. Maybe we can begin to use. Okay, I'll speak to that on Friday. On Thursday, let me not digress into somebody else's session. Now, I spoke about training. Now, DPO, this is another practice area that lawyers can provide, or this is another service that lawyers can provide. We act as external DPOs to a couple of companies, and individuals can act as DPOs, law firms can act as DPOs, companies can act as DPOs. So you're just providing, just like when we provide in-house counsel, external counsel services, or when we second lawyers to go and act as in-house counsel in companies, or even when firms perform that role for companies. So this one is also some of the things that firms can do. But again, while you are auditing, you will check whether they have DPOs. Well, not all companies need to have DPOs, but you can advise companies that have so much to do with personal data, or that they process personal data in the regular course of their businesses, then they are required even by law to have DPOs. So I spoke about this earlier. Companies must have mechanisms to respect and to enforce rights. So part of the rights that people often invoke, some of them are passive rights, some of them are active rights. Active, they would have to invoke it. Passive, the clients need to enforce it even before the customers ask for it. The first one I want to talk about is right to information. You must check whether the client respects and enforces customers and employees' right to information. How do they do this? They have to proactively provide information without asking. Privacy notices, employees' information, sensitivity notices, cookie policy. They must give these notices so that people know that you are processing their data. People know how you are processing it. People know who you are sharing it with. People know how you are securing it. These are all the things that must be in the privacy policies or notices. Some organizations will even say they are not doing automated decision making, whereas they are, but because they don't even know what it is. But it is the place of lawyers to advise, oh, this one constitutes automated decision making. And if we are not sure, we ask the regulators. They should be able to provide clarity. Or we look outside Europe. The Nigeria data protection legal regime is fashioned after Europe, after EU GDPR. Everything, with the exception of just little. So if we can't find examples here, we can't find clarity here, we look outside where we can get persuasive. So I'm talking about rights, that's information. The other one is data subject access request, DSAR. That's when data subjects or customers or even employees ask. The one we always do is when we ask banks to give us our statement of account. That one, everybody does that, or most people do that. The other one that we do is when we ask telecommunication companies, service providers to give us our call logs. I remember in 2019, December 2019, I lost all my contacts. My children were playing with my phone and they downloaded so many things on it and the thing just went off. So I lost everything. I needed to retrieve I wrote one of my service providers and I told them I wanted my call logs between one period and another period. And one of Vazilo's customer care agents wrote me that no, they couldn't give me. I had to maybe swear affidavit, or I wrote them. First of all, this is a right. Secondly, you're providing a service. All you just need to do is for me to identify myself. And if I give you acceptable means of identification, then you should oblige me. I wrote them. I cited provision of the law. They sent it to me. There's another example. Banks, I had that with a bank. I registered a business name a long time ago. I misplayed the certificate. But I needed CAC to certify the certificate for me. So I needed the photocopy. I wrote the bank. Again, the customer care said, no, they don't give it. It is my personal data. It's my document. So I wrote them, cited provision of the law again. They gave it to me. So, it's our duty as lawyers to advise clients ahead that there are certain rights that you must oblige easily. Some you might want to verify, some you might want to check, some you might even decline. For example, rectification. There are some rectification requests that companies cannot oblige, especially in Nigeria. You are male, you send them your certificate, they have your pictures, they have everything showing that you are male. Then you now write them to change your sex to female. I know Nigerians will have problems with that, especially with laws with respect to same sex and homosexuality. But there are certain laws that there are certain rights that the client or the business provider must be ready to provide, but be easy to provide. Rectification of errors in names, errors in maybe date of birth, errors in even this one, if they don't ask. I know banks now ask. When you open an account about 20 years ago, your picture is different from what it looks like now. So you want to change your picture. I mean, those are things that they should be able to do for you. So there has to be a mechanism to respect rights. Those are things you will audit to be sure that the client has those things. I'm gradually moving to the end of this. Now, audit is not the end of the matter. And this is where our expertise, this is where our skills, this is where our knowledge comes to play. You have the audit has exposed gaps. So what do you do? Because it doesn't just stop there. Some people will just say we have filed audits and that's the end. If you have filed audits and the audit shows a whole lot of gaps and you're not filling it, and I suffer injury by virtue of the gaps you have not filled, you will still be liable. The law says you should employ or you should designate DPO. Audit says you are not designated. You file audits like that. Law says you should give me adequate information about processing activity. You don't have a privacy notice on your website. You don't have employees' privacy policy, or you even have, and that's another thing, you even have, but it is deficient. The lawyer or the person auditing is the one that should tell the clients about the deficiencies. Let me say this up front. Nobody is 100% compliant, not even my firm. We are not. But maybe just like they say in election petition cases, substantial compliance will help. Then it's a journey. So gradually we continue to build, gradually we continue to build, gradually we continue to build until we're able to, not even the biggest of the companies in the world. Yesterday, we were told of British Airways data breach. You see all these big companies being fined all over the place. So after audit, what do? You report, you send a report to the client. The report will show all these, and that's a very tricky place to be. We have lost briefs because of reporting before. I mean, because the client didn't want the report, what was there, but we couldn't help it. Your website does not have this thing, except you put it there. You have not trained staff in the past 1 year, 2 years, except you do that. The person acting as your DPO has no certification with respect to the person. From what we could see, the person was just someone designated doing something entirely different from privacy, from data protection, from IT. So the person was just lost. Those were the things we would put in the report that would help the client. But it's a tricky thing because some clients are not happy with it. But if they're not happy with it, what do? Maybe you can remediate before you file. That's filing. You have a time frame to file. You don't have to finish the audit today and file tomorrow. This is what we have found. Before we file, if there are things we can remediate so that you can be better in the filing, possible. Then after filing is done on NDPC's portal. Payment of certain fees, answering the questions, uploading your documents, that's the questionnaire, and you are filed. And they have an annual list of people who are filed. Then, after filing, you now begin to look at the remediation. Remediation is not something we can finish today, and it's not something that is within the ambit of this training. So, but you just know that upon audits, you have to file. We have seen the biggest of audits. I mean, the biggest of clients that have been audited, and the clients will just say we've been audited. But auditing does not make you compliant because after audit, you need to do certain things. So it doesn't stop there. Auditing, the remediation, that's the goal, so that we can now begin to move towards plugging the gaps identified in the audit. Thank you very much. That's my time. I will now take questions before we get ready for my Lord Justice Harrison. So I've been able to manage my time well, so I think I have some time to answer the questions. Somebody says, how can a lawyer obtain license to audit? Please just go to the NDPC's website and you would see the rules keep changing, or the recommendation or the requirements keep changing. But just check so that you can see the current one. Somebody says, if you are going to get the paper, yes, the NBA sends all these papers after the last day. The NBA will collect all the papers and send to your email. Now somebody's asking if the exposure of emails and phone numbers which the NBA and their candidates harvest to inundate members with campaign messages during the election fall within the realm of data breach from the NBA or the Supreme Court, or what preventive measures would you recommend to be adopted by the controllers? I have written on this, actually. I have written like twice on it. Definitely that we can't sugarcoat it. Yes, this is an NBA platform, but we can't sugarcoat it. When you give our data to politicians to send us emails, and it's a data breach. It's even a breach of trust, because from the NBA's website, and I speak, and I hope maybe someone in the NBA secretariat can hear. Maybe they are here, maybe they're on the call, I wouldn't know. But I have said it over time, even from the NBA's website, we begin to search for the privacy notices and privacy policies. For a long time, they did not have it. I don't know if they have one now. And even if they have one, what communication do they give members on how they use our data? I mean, do I have the expectation that you are going to share my data with politicians who are going to be sending me messages and text messages? I do not think so. So, of course, this might be a conversation that the NBA wants to begin to have again, to say, it's a breach. It's a breach of trust. It's a breach of data when you share with, I understand if they share with partners, but sharing with politicians, I'm not sure I understand that. Is data protection applicable to all companies, irrespective of the number of staff? The NDPC will come out with their classification. Under the NDPA, there is data controller of processor of major importance, and there is controller of minor importance. We are waiting to see how they are going to demarcate and dichotomize controllers into this. So I do not think it would be applicable, because some people cannot afford to even engage a DPCO. So, I mean, because of their turnover. So it wouldn't be fair on all companies to be able to, that question cannot be answered now. But under the NDPR, the people that are meant to file, in terms of applicable, the law is applicable to everybody. But in terms of filing audits, the regulators will come out with their regulations on who should file and who not should file. But we are still using the NDPR. NDPR says if you process the data of 1,000 people or so, you must file audits. And for me, that is not very accurate, because hospitals that don't have more than 100 patients, are you saying they will not file audits because they don't have a, no, I don't think that should work in this new dispensation, because the kind of data you process should ultimately determine your obligations. Or what do we say about fintech companies who don't have so many, some fintech who don't have so many customers, but they process highly sensitive data. Now, from experience, most companies in Nigeria do not respect people's personal data. And you are looked at as a strange person when you complain about how your data is. Okay, I think that's just a comment, that's not a question. Is the NDPA applicable to all hospitals and medical institutions? Are they? I would say yes. Hospitals process sensitive data, people's health records, people's medical status. They do, they should. Is there any organization on data or data training we can join? Yes. So if you Google, you would see I co-founded an organization called the Privacy Academy with the Laden Silk, Mr. Uche Obiese, who spoke yesterday. If you Google, you will see the Privacy Academy. You can ask questions there on further training if you want to join. Now, I'd like to know more about DPO and the kind of role a lawyer can play acting as a DPO for a company. Now, I said it earlier, DPOs advise companies on compliance. They also liaise with the regulators on the company's data protection. So DPOs are like in-house counsel, but they advise strictly on privacy and data protection. There are some clients will service, but they have established law firms that provide legal services to them. All we just do is advise them on privacy and how they can be compliant. So that's what a DPO would be doing. You just want to be sure your company or your client is compliant with respect to privacy and data protection. What section of the law did you quote in your letters? You need to go and check again. Okay, under the NDPR, there is a different article that regulates data subject access requests. Under the NDPC, I think it's section 24 or section 27 or so. You need to just go check. That says the question that, section that gives obligation or mandates organizations to provide all this information. You will see it's section 24, it's between section 24 and section 30. Just go check. I'm not sure now. Now, somebody's asking what certification are required of DPOs. Good. Under the GDPR, nothing. GDPR just says knowledge and expertise also. And I think NDP also says knowledge and expertise and skills. Up until last year or 2 years ago, I had my master's. I did not have any certification in data protection. So for you to be able to advise clients in data protection, majorly, you might not necessarily be talking about certification. Except I want to be selfish. I say, oh, come and do certification. In the Privacy Academy, we have 3 certifications, actually. So these are the opportunities to talk about it. We have the associate, that's like the basic. Then we have the members, people who are quite knowledgeable. Then we have the fellowship. That's like the highest level now. So, but strictly speaking, the law does not say you must have certifications. The law just says knowledge. The law says expertise. But certification sometimes open doors where others would not open. So, I have lost opportunities in Europe because I did not have certain certifications. So I will tell you, it's quite important. At what point should we file audit? Assuming the company is about to launch. Yes. Yesterday, somebody spoke about data protection by default and by design. Or you also want to call it privacy by default or by design. While you are building a company, at the point of building a company or a product, you must have privacy embedded in it. So the audit, like I said, the audit is not because you have done business. The audit is to show, even at the point you are starting business. So the audit, you can file your audit even at that point. The audit will show what is left and what needs to be done. For example, you have set up a company, maybe the company is 1 month old. The audit says you don't have a website, or the audit says there is no privacy policy on your website. You will go and do it. The audit says you don't have a DPO. You will designate someone. The audit says you have not done training. It doesn't take anything to do training. You can engage DPCOs to conduct training. You can attend established academies that do training. You do the training. The audit says you don't have documentation on data protection. You prepare it. You get documentation, you localize it. So even at the point of starting business, you are starting on a very good footing. So you can do the audit at any time at all, whether you have started business or you have not started business. Once an entity exists, you must do audit. But NDPR takes 6 months of the beginning. So NDPR is giving you like some 6 months buffer. But there are companies that want to do business with NDP, with federal competition. What do you call them now? FCCPC, the Competition and Consumer Protection Commission. Before they give you license for digital lending, they want to see your audit. So audits can be conducted even the day you start. It will only expose the gaps, and you fill the gaps, and it helps you to even have a better standing with the audit. Now, do you need any other certification aside from being a lawyer to be a DPO? I don't think so. You need knowledge. But whoever is, clients now, clients will ask you, you are pitching for a job, they ask you, what certification do you have? So you want to show something. It might just be important. I can say, I did my master's, I majored in DPO. Data protection, my master's. Now I'm doing my PhD in privacy and data protection. So I mean, those things, they had to credibility, and they help you put your foot in the door. Anyways, now I have First Bank sending bank alerts of a certain customer to my email. I complained, but they have refused. This was a case we had for someone, and we got damages. So that one, I don't know why First Bank is like that, but I mentioned something about rectification, and I mentioned something about having this mechanism that helps you to enforce customers' rights. If they had a mechanism, they would see that this is an obvious data breach, and it is very reprehensible. Now, could you briefly shed some light on remediation? I'm not sure I can because of my time and because of what this training session is all about. I'm waiting. Sarah, please, once my Lord comes on the call, let me know so that I can quickly rush out of this. We just have some 9 minutes more. Now, if a company, good afternoon, you spoke on CCTV camera. What's the stance of CCTV with audio in the office without telling? Oh, that's a massive breach. You can't have CCTV in the office without telling employees that there is an audio, because what a reasonable person, or what is normal, is that CCTV only picks images. So if your own goes ahead to pick audio, you must inform. Whether it picks images or picks audio, you must inform employees. So it's a violation. And I also ask us as lawyers to advise our clients. It is not meaningful to have CCTV in every part of the office. It's a violation of employees' rights. They are employees, but before they became employees, they are first humans. So I even heard about a company that puts CCTV in a common area in the restroom. That's serious. It's a violation. It is. If a company promotes its experienced staff in the department to the role of DPO, is that enough to overlook experienced staff? Yes. If the staff, if the staff is knowledgeable with, because we have dealt with DPOs who cannot even relate. They were designated as DPOs, but they couldn't relate. It's completely, and we had a particular DPO that told the company that she didn't want to do DPO again because it was out of our league. It was out of our area of specialty, out of our knowledge base. So are you generally required to pay for rectification? Well, I think it depends on the industry. NIMSI, we took NIMSI to court because they were always asking people to pay for rectification. I don't know if with the new DGNA, if they are still doing it, but the court agreed with them that, I think my Lord is coming in. The court agreed with them that, yes, they should pay. Now, I need to rush because my Lord is joining the call. Now, what is the procedure for data impact assessment? How is it done? Now, one thing I need to say is almost everything we need for data protection is on the internet. Everything we need. All the forms, all you just need to do is to localize it. For data protection impact assessment, if you go online, if you Google data impact assessment test, you will see it. It's just a questionnaire. But the rider is, if you don't have at least a little bit above basic knowledge of data protection, if you want to conduct DPIA, how do you know the kind of remedy you are going to prefer? How do you know the kind of rectification you would ask them to do? How do you know how you even want to help their situation? Because data impact assessment shows you the risk and how to plug the risk. So you must do a measure of reading before you can do that. Now, how is it applicable to NGOs as churches? Yes, it is applicable. But again, I think when the regulator comes with their guidelines, we'll begin to know where churches and other religious agencies will. But of course, it is very, very applicable. In the UK, churches pay registration fees for the ICO in terms of their data protection, especially the big churches. Will progress be monitored during filing? Yes, that I can tell. The regulators, sometimes they reach out to some businesses. They have reached out to two of our clients before in the past that you need to do this, you need to do this, or you promise you're going to do this. So sometimes, but I don't think they have the manpower, but you don't want to take that risk. They might be reaching out to your clients, so you wouldn't know. And sometimes you even file audit and somebody else will go and report, maybe the client is violating. So now, how can you join the Institute of? So let's see, it's online. Just Google the Privacy Academy online, and you would see how that can be done. Now, in a bid to get investors, they request to view employees' payslip. I think it's a data breach, and even you can't even say if a prospective employer asks you for your payslip and you give it, the employer cannot rely on consent because there is imbalance of bargaining power. And that is where you will say that kind of consent is an invalid consent. Now, please, how applicable is audit to electronic filing of court process? I don't understand that question. In a situation where a person who is in possession of data shares to another who should be sued or held liable, the person who shared, released, or the person who collects. So number one, it will depend on the purpose of sharing. Data protection thrives on several principles. One of them is lawfulness. There has to be a lawful ground for sharing data. Is the person sharing for contract? Is it for public interest? Is it in the person's vital interest? Is it as the person consented, or does the law mandate them? So the question is blanket, but first of all, you must find out what legal basis. Now, for legal license, please go to NIDA's website and you will see that. What's the relationship between data protection and intellectual property? Yeah. So, I mean, it depends on the fact of each case. This does not have anything to do with my training, so I'm not sure I want to spend so much time on it. But again, copyright consists in intellectual work. Data protection consists in information that identify you. So there is always an overlap, but again, the court will have to conduct what we call the balancing test. But the question we always use all the time is where a photographer takes the picture of someone and the photographer wants to use it. That's copyright. But in terms of privacy, the person holds privacy right. And mostly in our jurisprudence, we understand that fundamental rights, most times, they trump all other rights. So if I say I don't want to be exposed, it has happened to me before. A photographer took my picture and used it on his Instagram page. I told him to put it down, and he had to. I mean, because the fact that you have the right to it does not now mean you will now override my own privacy. So these things, there has to be a balancing test to be conducted. Now, NIDA is no longer the regulatory body. The regulatory body is now Nigerian Data Protection Commission. I'm so sorry, everybody that is saying the website of Privacy Academy is not available. I will talk to the people back end and they'll see what they can do. Now, sorry, you will see all those things on the website when it comes on. Can both provision of the Cybercrime Act and Data Protection Act be invoked against a ban that allows some fraudulent employees? So cybercrime is criminal. Data protection is civil if an individual is invoking it. But if the regulator is invoking the NDPA, they have the criminal angle to it. So if you want to invoke, you would most likely be able to invoke the Nigeria Data Protection Act in the civil remedies, except you want to now report to the police and they take it in the criminal part. What's the possible remediation that captures biometrics? Yes, so this one again would have to go to organizations that capture people's biometrics. You would have to go to their privacy. Sorry, my time is up and I don't want to hit into my lunch time. You can always reach out to me on LinkedIn, and if I can answer some of these questions, or you reach out to Mr. Babatunde Bamboye. It's his class I took, so I mean he might also be able to be answering the question. Now, distinguished learned seals and judges, I'm honored to hand over to my Lord Justice Harrison. And one of the reasons Justice Harrison was invited for this was one decision that Justice Harrison gave. It's a novel decision, and it's already at the Court of Appeal. Coincidentally, I represented one of the parties, and it was spousal privacy. Some of the things that we need to begin to explore, where a privacy issue happened between the husband and wife, and the wife, a strange wife, actually took the husband to court, and my Lord gave damages in favor of the wife, but we have appealed. And we will see how the Court of Appeal, we will just need to develop this jurisprudence so that the kind of attention we've been giving privacy needs to begin to change, because privacy is much more important than what we used to see. My Lord, we thank you so much for your time. My Lord, you have the floor.
Yeah. Hello, good afternoon, everyone. I hope you can hear me.
Yes, we can.
Hello, you can. Okay. Yeah, because sorry, I didn't prepare slides. You have to take me well, I'll send something later. We have a lot of deadlines and pressure. So the topic to at least just put some thoughts on is litigating privacy and data protection under the Constitution and the Nigeria Data Protection Act 2023, which has just been signed into law. So I can say it is not tested. The Nigeria Data Protection Act was just signed by Tinubu, I think in June, just recently. So it hasn't really been tested litigation-wise, but things had been happening before. So, well, first of all, I'll first talk about privacy. We know the Constitution under Section 37 guarantees our privacy. But when the Constitution was being written in 1999, this issue of data was not really in the forefront. It wasn't in the forefront. So a lot of people didn't envisage that it will come to a time that has to be protected. And litigation before, the law before now was more concerned about, corporate bodies, they should protect the data within their space and stuff like that. But I kind of am going to concentrate a little bit more on the private individuals, which is what this new act is about, natural persons. Because before, nobody was really too interested in them as against each other. I know the act is also concerned about corporate bodies using natural persons' data and stuff like that. But what of individual to individual? So I will say, and I firmly believe, I'm going to also use that case Mr. Babalola spoke about as a case study in my discussion. I firmly believe that the right to privacy under the Constitution extends to data protection. It covers it. So now let's look at this new act. The new act says in Section 1, subsection A, that it's to safeguard fundamental rights and guaranteed under the Constitution of the Federal Republic of Nigeria, So that is our chapter 4. And now Section 3 gives a caveat that Section 3, subsection 1, that it shall not apply to processing of personal data carried out by persons solely for personal or household purposes. Now, the case Mr. Babalola talked about, when I saw that, I looked at it that phone and her other when they were still married. So it was was he entitled to it then? But there's a proviso that says that such processing, it should not be for purposes that constitute a violation of fundamental right of privacy. So whether it's a personal issue or household issue, it must not violate the fundamental right of privacy of a data subject. So we see that whether it's husband and wife, whether it's brother and sister, father and parent and child, it is still covered. And then I would like to just also refer to Section 31, which talks about children. because we know sometimes you see a lot of, like Mr. Babalola spoke about pictures, you see pictures of children who gave consent. Their parents are supposed to give consent, or their guardians. And then it must, however, not be inconsistent with the provisions of the Child Rights Acts, because if it is, it can lead to litigation. And then section 46 says the aggrieved data subject may lodge a complaint with the commission. Well, I hope the commission has been established now and that there may be sanctions. Shall review within 30 days. And then, but section 51 says a data subject who suffers injury or loss or harm as a result of a violation of this act by a data controller or data processor may recover damages from such person in civil proceedings. That is a litigation, a court case, or it can even be, it could be alternative dispute resolution. It could be anything. Then also, it says something I like here, that there can be joint or vicarious liability by both body corporates and their principal officers. So this is not a case of just a company just did something. Even the principal officers will be liable. Yes, so we know that. Then another thing about this, though, is that it is restricted to natural persons residing or doing business in Nigeria. So if you are not within Nigeria, I look at it that you are not protected by this act. And it now reminds me of the incident that happened with the young boy in America, and how some people, well, that one had gone into crime anyway because they were extorting him and blackmailing him, and it led to the boy committing suicide and stuff. But I now look at it, if it were happening in Nigeria, we know there are things like that, maybe between people in school, and they are bullying somebody. They are probably not extorting, so they are bullying somebody, and maybe they got some pictures and they are threatening that they are going to expose the person and stuff like that. And then I begin to wonder, if that litigation comes, it will probably come under enforcement of fundamental human rights, that a right to privacy, because only God knows how they got the pictures anyway. And well, my personal opinion, was some agreement before I gave you the pictures, and maybe they were in a relationship or something. It still does not give the person a right to now publish the pictures. So as I said, I'm going to use this particular case, the case Mr. Babalola spoke about as a case study, because these cases don't really come to court because people probably don't know their rights. They don't know their rights. So this particular case, I will not say the name of the case, maybe until it is over in the Court of Appeal or Supreme Court. But as he said, it was a wife who sued not only her husband, but sued his employers that, okay, they had kept her information and they were utilizing her personal information, and she wanted damages against both of them. Well, in looking at the facts of the case, then I saw that the employers had nothing to do with it, because she willfully chose to send some information to her husband's official email instead of to his personal email. Even though the information the husband wanted to use, he actually hacked her phone to get it. So it's not as if she even gave it to him willingly. But in looking at it, I felt it was because I couldn't even find any precedent for such a case when I was writing the judgment. And then all we had was the Nigerian Data Protection Regulation 2019. At least we now have the law, the 2023 law. And the defense was that, oh, it's a private matrimonial affair. It should not, it's not public. It's out of this. But the way I looked at it is that if you want to publish my private information, you have brought it into the public domain. And based on that, you should be liable for infringing my fundamental right to privacy. And based on that, I felt it was a breach, and I actually found it was a breach, and I they should go and find out because of oh, they were, oh, okay. Oh, okay. Okay, sorry. So they should so I found that since he was holding her personal information without her consent, one, I even said everything should be deleted from wherever they are. And also, I found she was entitled to damages. I think they raised an issue that she shouldn't have come to court straight. But as at then, all these panels and stuff were yet to be set up. So they were yet to be set up. And now, aside from this was now person to person, but I think it applies whether the people were friends, whether it's even a parent who is using the child's information, and it's not in accordance with the Child Rights Act. I think it is a violation of the right to privacy. And then when we look at the corporate bodies, in actual fact, the corporate bodies and how they utilize information. I think when I came in, I heard some little talk about the church or something. I didn't hear much, but I'll never forget that once I made a donation to the Christian ministry in the US, and you will know they shared the information because I was now inundated with requests from all over. And I said, there were so many requests that were just coming. And I just had to, I didn't respond to them, but it got to a stage they were a bit irritating. It got to a stage they were a bit irritating, and you will know that definitely the information was shared. And in those days, there was even nothing like consent. At least now we know there are all these, what I will call small print that nobody ever bothers to read, and you just click on it because you want to go on with what you are doing. And then invariably inside that small print is a consent that you agreed for them to share. So, well, based on that, I think that is about all I want to talk about, because the litigation of it is still very, very, we don't have a lot of litigation yet. We don't have, but one thing I can say is that the data protection law does not limit the rights under the Constitution. So I feel the sky is the limit. And it even extends to personal communication and also personal data. So I think on this I will stop.
Thank you very much, my lord. We have a few questions for your lordship. One person is asking, is it possible for someone to sue a blog for keeping a damaging pronouncement of court on its platform? Even What?
Is it possible for one to?
For someone to sue a blog that's like an online
Okay,
newspaper
yes, an online blog,
for
yes.
keeping a damaging pronouncement of court on its platform, even after a higher court has given another pronouncement vindicating the person.
Well, my belief, nothing ventured, nothing gained. You should try it. Let's test it. Law is all about testing. But the thing is, at least the blog has some identity. It is those things that don't have any identity. You don't even know where, if you want to sue the blog, what is the name you will sue? Who will you sue? Is it the owner of the blog? What is the, okay, you could serve the person online. I'm thinking of procedure now, of things you can do, but nothing tested, nothing gained. Because I recall I had a case once where, although they brought it under defamation, and it was a question of, okay, put it down. But okay, they said, yes, we have, but every time the person goes online, it is there because it has spread. And you know how the internet is just so much worse than a newspaper or TV. It keeps on going. People are reposting and republishing it. So, but I think if we make one blog an example, maybe it will teach them. They have to learn.
Thank you, my lord. That reminds us of one case that the Lagos State High Court had an opportunity, but my Lord Justice Akikugbe did not touch on the substance of it. He was struck out on technicality. A priest who was dismissed in the UK came to Nigeria and he said he couldn't find a job, so he sued Google for them to take off his story about his conviction. Yes, on the ground of some technical ground, the court did not get to rule on it. But another person is asking what happens when an employer accesses the personal information of an employee and uses the same personal information. When an employer accesses the personal information of another employee and uses the same because it was sent to the employer it was sent through the internet. Does the employee have a right in this instance?
Does the employee have a right to? The employer is using the information against the employee.
Yes,
sorry,
my lord. I think that's the question. Even me myself, I'm not so clear about the question. But I think what the person is asking is if an employer gets an employee's information.
You know, employers sometimes do that. I mean, they do things like maybe some bad blood or something, and the employee may not really be guilty of anything. And then they put something, they put a disclaimer. In those days, they put a disclaimer in the newspaper. And you know, when you see a disclaimer, you automatically believe that that person must have been fraudulent, whereas it is not so. So for me, such a to test, you need to just test the law and find out. If, for example, maliciously, let's use the word maliciously now, and wrong information or innuendos and stuff about an employee, which is now obviously making it difficult for an employee to get employed elsewhere, I think the employee should sue that employer. Should sue the employer, and depending on the facts, especially if it is not true, they can get some damages if they come to my courts.
As lawyers, we don't always get the opportunity to ask judges questions. Now that we are taking the best advantage of it. Now, someone is asking, my lord, I mean, why is the laws restricted to natural persons?
Time people try and call me because they don't have reason. So sorry about that. Yes, can I have that question, please?
Why is the law restricted to natural persons? Can't artificial persons also take advantage of data protection laws or data breach?
But you know, we have to stick to what the law says. I feel, okay, let me put it this way. If the data protection law does not extend, because when I looked at it, it said it's a law to protect natural persons. I don't think it went on to talk about, if I recall, it didn't talk about corporate bodies, but under section 37, the Constitution, a corporate body can actually come forward and ask for protection and ask for damages. I know I've given a company damages before on that. They say their right to privacy. Yes, once they can prove it, the important thing is to prove it.
Yeah, thank you, my lord. This one, it's personal to me because I have tried it, but I'm just now. This is just seeking your lordship's opinion. In Nigeria, the procedure, and this is when we start talking about right to privacy, we also need to start bringing it home, bringing it to the court. The procedure in Nigeria is to always disclose the names of parties, like name of a plaintiff against the defendant or the applicant against the respondent. And I understand there's a decision of the National Industrial Court where a person who had HIV approached the court. It was an employment case, and of course, to protect his privacy, he approached the court with an application asking the court for him to use a symbol or a code, initials. So he just approached the court for him to be able to use Mr. X against the name of his company. And graciously, the court granted it. But my lord, we have, we haven't seen anything similar to that in the High Court of Lagos State. My lord, if the tables were turned, what would be my lord's opinion with respect to trying to enforce?
For me, looking at it, first of all, for example, if the party is a child, I would definitely grant it, because I know under the child rights law, there is something there about protecting the identity of the child. You know, we are hampered sometimes. We are hampered. If, for example, there is no law backing us up, no rule, no regulation, it may be a bit difficult. But for me, in such a situation, it's a sensitive issue, and inherent jurisdiction of the courts, I may just say, based on equity, I could grant it. I'm a bit, what will I say? I'm probably a bit, I don't get hamstrung. I read more into what the law is saying than maybe it is saying, just to make sure justice is done. So for me, depending on the facts and the circumstances, I personally may grant it, but I would also want the lawyer to try and do some research to back up his. But as I said, if it's a child, definitely I wouldn't even think twice. Because we want to protect the identity of that child. So
good to know. Thank you, my lord. I think we just have one more, and is the act really safeguarding digital rights or human rights with the provision on limitation of action? Because the act limits also, there's a provision on limitation of action in the act. So this person is asking if the act is
protected.
Yes.
But you know, if, for example, you have been limited under the act, the Constitution is still there for you now.
Yes.
The Constitution, you just have to, think outside the box. You come under the Constitution. That's it. You come under the Constitution, fundamental rights. So you are still covered, and there's nothing limiting you there, if perchance you are already limited under that. So that's
Thank you very much. Thank you very much.
Thank you.
He's asking, will the law, and this is a good one, will the law assume the role of a controller in matters before them? The Nigeria Data Protection Act has provided obligations for controllers. With respect to matters before the court, will the court assume the role of the controller and subject itself to the obligations?
Well, the way I see it, if maybe a case comes to court and they say XYZ company has not carried out what they are supposed to do, direct them to do it or something, the court will give the order, but it may still now be the controller that will enforce it and ensure it is done based on the court order, because the court will not go there itself, to do it. And, when you think of our enforcement procedures under the sheriff and civil process, you begin to wonder, okay, how will that be enforced? So, you have to think of that procedure. But I believe we can give an order quite all right, but then the real enforcement may still have to be carried out by the controllers. And then if they don't carry it out, it may be something, it may be locked up, it may be something may be brought down on the internet, or there are all those other things that can be done.
As the copies is. My Lord, we're so grateful for your Lordship's time. I see a few people raising their hands. If I may quickly just call the people raising their hand, because we still have a few minutes to spare.
We still have a few minutes.
Mr.
Okay.
Emmanuel Thiaba, please, you are raising your hand. Do you have anything? Or people, I'm not even sure people are enabled to talk now. Sarah, are people enabled? I see hands up. I don't know why they're raising their hands, but anyways, we would in that case maybe excuse my Lord, and I see if there are other questions we can quickly answer, then we can call it a day today. I see someone is saying there are employers who carry out survey on activities and charts of their while they are at work, probably when they are suing the, is this a privacy?
Okay. But is it an invasion of their privacy?
Yes, Lord.
Now that's a bit of a tough one, because I think I know a lot of employers do it. And because like people can just tell me that, they know every site you go to. So like if you go to, maybe you are working with A and you go to their competitor's site to see maybe there is an opening day, they will know. So obviously you are being monitored. And then maybe some people, they say, they noticed an employee went on a pornographic site, and based on that, he will be called and he may even be sacked. So that one, well, because it is not being published, I don't know if we can say it is a bit of an invasion of their privacy. If we look at it, how does it hurt them? What loss are they suffering? What injury have they suffered? That's how one will weigh it. So I don't know, but it can be tested. Because it is probably like putting a device in somebody's house and
surveillance. That's
surveillance.
Surveillance, yes.
Like a surveillance. Yes. But I know a lot of offices actually do it. More because maybe they don't want you to be wasting their office time on the internet, and you are using their internet and data and everything to go to sites that are of no benefit to them. So when you look at it, you have to weigh both sides, the interest of the employer and the privacy of the employee. And then my own view, the employee should go to any site he wants to go to in his house using his own data and his own device.
Thank you, my Lord. Very quickly, Emmanuel Thiaba, please, can we have you? Oh, I thought Emmanuel was permitted.
No, maybe he should type his question so you can say it for
Bola, Abibola, please, if you can talk. I know some people raised their hand, and I thought the person has been enabled. So, Ugochukwu, maybe people are raising their hands and they were not aware. Psychology. Anyways,
maybe.
Well, in the absence of any.
Sir, can I talk?
Yes, please go ahead. Go ahead. Go ahead.
Okay. Thank you very much, my lord, for the insights.
Yeah.
Thank you, sir, to all the organizers. So my question is, there are instances where we insert the kind of transactions we've done on our CV. And, you know, sometimes we also write, you know, the details of the transactions and summary, and then the parties involved. I want to ask, that's for private contracts, especially, and I want to, my question is if that would be a breach of the data of the individuals involved in this transaction.
I kind of wouldn't say so, because one, you are not causing them any injury. You put it in your CV and you are saying, this is what I was involved in. I was involved in the rights to issue or XYZ, or, you know, things like that. No, I wouldn't say that is an invasion of their privacy. Or unless the people you now show it to maybe start publishing it, maybe. But aside from that, no, I don't think that is no. I don't think that would qualify.
Someone is asking my lord to reconcile. Someone is asking my lord to reconcile the provision of the Nigeria Data Protection Act with Section 29 of the Electoral Act, governing the publication of candidates' personal data.
Oh, well, in respect of that, when you set up yourself for elective office, you are in the public glare. You are definitely, you are putting yourself out on a billboard, more or less. So I don't believe that is, let me put it this way. You yourself submitted your data and you know what it is going to be used for. It is not just for it's not just for INEC. It is for the voters to know who you are and whether they want to vote for you. I don't think such a person can succeed in saying that his data was put in the public. You want to contest for an electoral position? No. For
all
that,
right.
I doubt.
Thank you, my lord.
But it should be tested.
so many things to be tested.
Yeah.
Max, have you been permitted to talk? I see Max Kongwe here. Max, are you still on the call? Okay. So, Ganiu Smith, are you still on the call? So many hands up, yet Maruf.
Oh, we probably can't take everybody.
We can't take everybody. My lord, I think that we'll be drawing the curtains on that.
I actually saw something highlights just now, and the person was saying something about, must somebody have suffered an injury before you can say there is an infringement? That what of the place of consent? Yes, I saw that somewhere. So for me, I feel if, depending on whether it's a corporate body or an individual or anything, and you specifically tell the person, I do not want my information in the public. Like I think Mr. Babalola said he didn't want his photograph on Instagram for a particular, that person has been told, whether you are suffering any loss or not, you have not given your consent. Definitely you'll be entitled to, one, you'll be entitled to sue, and two, you'll be entitled to damages.
Yes, Mr. Okereke, Obina Okereke, are you here?
I just saw that highlight.
Okay, thank you, my lord.
Okay, thank you.
That's all for today. That will be all. Thank you very much for everyone who joined the call. And we're sorry that Mr. Babigwe just sent me a text now. He's just landing, unfortunately, taking this class. And tomorrow is another day. We have
another two fantastic professionals coming up tomorrow. Mrs. Jumoke Lambo, the partner in the UUBO, and Mrs. Dagabana, she's the secretary of the National Identification Management Commission. Two fantastic women coming to speak also on different aspects of privacy and data protection laws. Thank you very much for your time. See you same time, same place tomorrow. Thank you.
Thank you. Bye-bye.